Everyone. Hey everyone, Dwayne Boswell O'Shell here, and it's Friday 11:30, so we are going to get started with our Ask an Attorney portion of our live Facebook. Um, I just wanted to say thank you to everybody that's been watching these. It's really been a boost to morale and the whole firm. So thank you, and keep watching and sharing, and I will keep providing some information that hopefully is helpful to everyone. So let's talk about um, where things are standing with COVID. That's kind of been how we've been starting things. And um, right now, Neighbors Landscaping hasn't come yet. They may come, which means my dog may go crazy. Um, and we'll just have to deal with that because that's how things are going right now. Um, so COVID, it's hard to get any kind of good statistics or read on what's been going on with COVID. One day we had some really low hospitalizations, and then a couple of days ago we had a really high hospitalization day. So it seems to just keep getting that U pattern, up and down, up and down. Um, we're still not in any kind of danger of overflowing the hospitals. It seems we're still in the green range. So when we get into yellow, we're approaching their normal capacity. And when we get into red, then we're into the capacity that they expanded in expectations of COVID patients coming in. So that being said, we've got some updates for the courts. We just got some new, um, I guess, guidance out. So the Supreme Court issued their 17th emergency COVID statement. And I'm looking at a different screen. That's why I'm kind of looking off to the side here. Um, so they've given a little bit of guidance, and as you know, subject only to constitutional limitations. It says all courts in Texas may, in any case, civil or criminal, they have to avoid risk to court staff, parties, attorneys, jurors, and the public, and they have to get a participant's request before they can force you to come into any kind of court hearing. Um, so the courts can't modify or suspend, or they can modify and suspend any and all deadlines and procedures, whether prescribed by statute, rule, or order for a stated period. And right now they're saying that it's going to end no later than September 30th of 2020. So it looks like they're starting to prepare for courts to kind of operate how they have been through September. Now, it doesn't necessarily mean that's what's going to be in reality happening, but that is what this order is implying. In all proceedings under subtitle E, Title 5, so that's going to be CPS cases for child removals. So in those cases, the courts are mandated to basically commence trial within a year of the child's removal or temporary orders, or it's an automatic dismissal of those cases. Now, in some circumstances, they can be extended for another 6 months, um, but it's an automatic dismissal without any further court hearings if they don't meet one of those deadlines. Well, that deadline has now been extended for another 6 months, and it will extend the dismissal date from 180 days from the date of this order. So if you had a case that was coming up on their 18-month deadline, it has now gotten a 6-month increase to that from the date of this order, which was a couple of days ago. They can allow or require anyone involved in any hearing um, to participate by teleconferencing, Zoom, phone, any other means that they can. So that's still being encouraged. Um, they're going to consider as evidence. This is, I kind of thought this was interesting. Any sworn statements. That's usually not something that's typical, but they are now going to consider sworn statements made out of court or sworn testimony given remotely out of court by teleconferencing and video conferencing or any other means. Um, they're going to allow those now. So that's some good news of making some things a little easier, but there is some logistics, of course, anytime that we are dealing with a teleconference, communication with a court, um, just the live action that usually goes on in a courtroom. Um, it's got some other guidance. you can find all of the requirements that they're having. Courts are ordered not to conduct in-person proceedings contrary to any guidance issued by the Office of Court Administration um, in regards to social distancing, maximum court or group size, and other restrictions and precautions. So one thing to note is prior to holding any in-person proceedings on or after June 1st, and this says any in-person proceedings, a court must submit an operating plan that is consistent with the requirements set forth by the Office of the Court Administration guidance for all court proceedings. Um, so that means that they've got to send a report in saying how they're going to operate and how they're going to meet these guidelines before they're allowed to hold, it says any in-person meeting. I think some courts are doing on a case-by-case basis. There's some guidance for grand juries. There's court may not hold a jury proceeding, including jury selection or jury trial, prior to August 1st, unless there is a court or there's an allowance in this order. And there's not a whole lot of room for that. So I would suggest if you really want to know everything that's in this, there's quite a few little nuances in this. Just go and look at the 17th emergency order from the Supreme Court of Texas. If you just Google that, you'll be able to find it. But basically, things are kind of in a holding pattern as they have been for a while. In Harris County, they have actually they put out a letter talking about. I'm going to see if I can find it. It keeps disappearing on me, but about how they're going to be handling things moving forward, and that was put out actually yesterday. So I would encourage you to go to the courts in Harris County if you're in a family court and just read this. It's beginning June 1st. They will, on a very limited basis, be hearing some non-essential matters in person at the courthouse, but those have to be arranged ahead of time. So if you have not heard from the court that you are having a hearing in person, do not go to the courthouse. They're also going to be practicing social distancing, which means we're not going to be able to try to settle these cases in the hall like it happens a lot of times. So all of those are going to have to be, the settlement negotiations need to be done ahead of time because you're not going to be able to get within 6 feet of the other side. So unless everybody wants to be yelling across the hall at each other trying to settle cases, that's not going to be something that's going to happen. Courts are also going to be making reasonable accommodation for anybody that's in the vulnerable populations, and that's going to include being, allowing you to appear by teleconference, Zoom meetings, that sort of thing. So just get with your attorney or contact the court and just see where things stand before you just show up for any kind of hearing is basically what's being said. So the other thing I want to talk to everyone about today is mechanics liens. So during COVID, I've noticed, getting some work done on my home, that we have contractors that aren't dealing, in contracts. They're not getting contracts for the jobs that they're doing. And then when they're not getting paid, are they allowed to put a lien on someone's home in that case? And mechanics liens are very, very tricky. If you know how to do them, they're not real hard to do. So I would make sure before you just start thinking you can put these liens on someone's home that you go and do your research. And it makes a difference whether we're talking commercial or residential, and if that residential is somebody's homestead or not. So it also makes a difference if you're a general contractor or a subcontractor. So there's a lot of requirements that have to go out there and be provided to a homeowner prior to work commencing, and in order to make sure that there's some allowances to be able to put a lien on. Now, one thing that a lot of people don't know is if you're a general contractor, you can put a lien prior to work commencing, and then you do a release when you're paid. It's a very, like I said, tricky situation. Make sure before you just go out there and start putting liens on people's property that you at least do some research or you consult with an attorney to make sure that you know your rights and you do it properly. Because last thing we want is you put an improper lien out there, and there are some severe consequences for that if that happens. So mostly what we're going to be talking about is somebody's getting work done on their homestead. That requires some very special steps to be taken at the beginning. One, you're going to need a contract in writing that outlines the terms of the job, um, when things are supposed to be paid, how things are going to work, and allows you to put a lien on. There's a required warning that has to be put in that contract, and the contract would have to be attached to any lien notices. There's also a mandatory disclosure of subcontractors and suppliers. You have to provide a list to a homeowner of every subcontractor and supplier that you're going to be using, unless you get a waiver signed by the homeowner that they don't want that list. And this just protects the homeowner in case a subcontractor doesn't get paid or a supplier doesn't get paid, something happens there. The subcontractors are allowed to place a lien on the homeowner's residential property, and that can be detrimental to the homeowner with no fault of theirs if the general contractor is the one that failed to pay. So they need to have a list of the subcontractors and suppliers, and that has to be done before any work is started. There's a mandatory disclosure statement that has to go to the owners, and that has to be, and it's required by law. And if there's the written contract, it has to be a part of that contract. There's an important notice that you have to make sure that a residential construction uh, provide the person that you're providing the residential construction to gets. And it's language is all spelled out, and it just needs to be in writing and given to the homeowner before. Now, if the property is a homestead, the contract has to be in writing. There's some give if it's not a homestead on whether it can be in writing or oral. Enforcing an oral contract is very difficult because it's a he said, she said type of situation. Um, the so the contract has to be in writing. It has to be signed by the original contractor and the owner before work begins. And if the owner is married, then you need to have the spouse's signature as well. So you need to have all owners on that. Um, so if you've just looking over here to make sure I've covered everything on that. So it's pretty, there's a lot of deadlines and some weird things that go on with when can you make the lien, what are the notices, when do you have to send the notices. And so I would just really encourage anybody that's in the construction industry, or you're providing services to a homeowner worked on their home, something that would be covered normally by a mechanic's lien, to talk to an attorney, get and make sure that you know all your rights before you start just putting liens and property records on people's homesteads. Um, so I've got a question here. It says, how does it work if you paid and have no work done by contractors or half the work done? Well, really the only thing that you're going to be able to do is a breach of contract. So if there's a written contract, it should have the terms of when work was going to be performed and how things are being done. If it was in an oral contract, it makes it a little more difficult to enforce, but the fact that payment was done and you can prove that the work hasn't been completed, and especially if you can prove when the payment was made and there's been a substantial amount of time that's passed, then in that case you can probably pretty easily take it to court and enforce, either do a specific performance, which is making them do the job, or to get the money back for the portion of the work that they didn't complete. So there's not a whole lot that you can do other than getting a judgment. And once you reduce something to a judgment, then you can reduce that to a judgment lien that can be put in the property records as well. So hopefully that answers that question. Like I said, there's a whole lot of other things. And if you're a subcontractor, there's some additional things that you need to do, additional notices. There's time deadlines on when you send out notices. So if it's anything that anybody's interested or you want more information, just reach out to me. You can get a hold of me at Duana, Duana, at boswelltexaslaw.com. And I will be happy to answer any questions that you have and see what we can do to help you out to make sure that you're protecting yourself and your business. Um, we're also going to be, I'm really excited, we're going to be rolling out our business subscription plans, and that should be coming out hopefully by the 1st of June, and you'll be hearing more about that. Got one more question coming in. Can you put a lien on someone if you lent them money for their business? No, there's really not any liens unless you get the judgment. So, it's going to have to go through a court system and you get a judgment, and then a judgment lien can be filed in property records. And that's about the only way that you can put a lien on anything. And you can't force. So with the mechanics lien, if it's done properly, you can actually force a foreclosure in most circumstances, not all necessarily, but a judgment lien cannot do that. So it kind of just sits there in the property records as a cloud. So if that property is ever sold and the title company does a search, then it's going to come up. But really, unless you're a provider for contractor, general contractor, the lien is going to have to be a judgment. So, well, I just want to say thank you to everyone that's here and listening. And, Janelle, thank you for asking the questions. I appreciate that. And like I said, any more questions, just reach out to me and I'd be happy to do that. Right now, we are offering a free contract review. So just send me a contract, I'll look at it and we'll have a conversation and I'll give you some tips and pointers on how to improve it. Or if it's perfect, I'll let you know that as well. No obligation. You don't have to hire me. It doesn't cost you a thing. I just want to make sure that all the small business owners out there are being protected. So have a good weekend. And hopefully our weather improves and we'll see you next week. Have a good one. Bye.